This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of these videos. Today I'd like to talk about diminution of value with regard to automobile property damage. When a car is damaged in an accident, then repaired, the resale value may be less than that for a comparable car that has not been damaged. In other words, the damage results in a reduction or diminution in the resale value of the auto. An insured's claim for this reduction in value may be made against a third party that negligently caused the damage to the insured's auto, or it may arise from a first-party claim against the insured's own physical damage coverage. With regard to first-party claims, while it is perhaps arguable, the ISO contract language specifically in the limit of liability condition appears to cover only the actual cash value of the damage or the actual cost to repair the damage. There is nothing in the policy wording that even appears to contractually cover any reduction in market value, even if the insured is able to prove the amount of reduction in value. On the other hand, the policy clearly allows the insurer to deduct for betterment or depreciation, although the burden of proof is on the insurer to demonstrate such depreciation or betterment. In physical damage claims, the policy would allow the carrier to deduct for an improvement in the value, that is, betterment, due to repairs with newer parts, but will not compensate the insured for a reduction in value due to the same accident. Third-party claims for diminution in value, on the other hand, have generally been found by the courts to be covered by auto insurance, since the measure of damage in tort claims, which the insurer promises to pay, is the difference in value of the property before the loss and the value of the property after the loss. For example, a Texas court found that the legal liability for third-party damages includes diminution in value. The majority of states that have considered the issue have decided that an insurer need not pay for diminution in value because 1. The policy contract does not promise more than the cost to repair or replace. 2. The language repair and replace is not ambiguous. And 3. The language does not contemplate payment for diminution of value. Some states have held otherwise. For example, in Georgia, the Supreme Court in State Farm Mutual versus Mabry, a 2001 decision, found that the public policy of the state required insurers to pay the diminished value as well as the cost of repair of an automobile, even if the insured does not make claim for the diminished value. The court held that, quote, the fact of physical damage resulting from an event covered by the policy can reduce the value of a vehicle, even if repairs return it to pre-loss condition in terms of appearance and function. The policies issued by State Farm obligated to compensate its policyholders for the loss of value, notwithstanding repairs that return the vehicle to pre-loss condition in terms of appearance and function, if the repairs do not return the vehicle to its pre-loss value. And State Farm is obligated to assess that settlement of loss along with the elements of physical damage when a policyholder makes a general claim of loss. These same principles have long been applied under Georgia law in cases involving the proper determination for measuring damages to real property. As a general rule, the measure of damages in actions for real property is the difference in value before and after the injury to the premises. The Georgia Supreme Court has consistently held that the measure of damages in such case is intended to place an injured party as nearly as possible in the same position they would have been in if the injury had never occurred. Moreover, diminution in value is an element in determining the proper measure of damages to real property. In applying these principles, the Georgia Supreme Court recognized that under Georgia law, cost of repair and diminution in value can be alternative, although often interchangeable measures of damage with respect to real property. Similarly, in Hawaii, in County of Kauai versus Pacific Standard, diminution of value was used to establish value for the purposes of condemnation, and in Clog Holdings versus Bailey, diminution was used as a method of establishing values for loss to real property. Whether Hawaii will use diminution in an auto insurance situation has not yet been resolved. In Mississippi, in Potomac Insurance versus Wilkinson, a 1952 case, it was held that if, despite repairs, there remains a loss in actual market value, that deficiency must be added to the cost of repairs. On the other hand, in Texas, Carlton versus Trinity Universal Insurance Company, a 2000 decision of the Texas Court of Appeal, found that where an insurer has fully, completely, and adequately repaired or replaced the property with other of like kind and quality, any reduction in market value of the vehicle due to factors that are not subject to repair or replacement cannot be deemed a component part of the cost of repair or replacement. Also, the plaintiff could not recover inherent diminished value under the unambiguous terms of the standard Texas personal automobile insurance policy as a matter of law. By statute, North Carolina permits third-party claimants to demand that auto insurers participate in a non-binding appraisal process. The requirement is limited to when the claimant's and the insurer's estimate of diminution in fair market value is greater than $2,000 or 25% of the fair market value of the vehicle prior to the accident. The statute provides that for an appraisal similar to a fire insurance appraisal, the unusual nature of the law is that it gives third parties rights directly against someone else's insurance company. The third party is not a party to the insurance contract, yet it has been given rights that arise out of that contract. There is no case law directly on point yet, but analogous case law suggests that claimants will not be allowed to bring lawsuits against insurers because they have no privity of contract with the insurer. Notwithstanding, courts can only suspect that the new appraisal process will bring about novel lawsuits by third parties against auto insurers. As a result of Georgia's Mabry case, the Insurance Services Office, the ISO, has issued an endorsement to avoid the diminution of value issues that reads, quote, "This endorsement changes the policy. Please read it carefully. Coverage for damage to your auto exclusion endorsement. With respect to the coverage provided by this endorsement, the provisions of the policy apply unless modified by the endorsement. 1. Definitions. The following definition is added. Subquote, diminution in value, close subquote, means the actual or perceived loss in market or resale value, which results from a direct and accidental loss. 2. Part D, coverage for damage to your auto. The following exclusion is added. We will not pay for loss to your covered auto or any non-owned auto due to diminution in value. This endorsement must be attached to the changed endorsement when issued after the policy is issued. This is called a Personal Auto Form PP 1301-1299 and is now being added to almost every auto insurance policy insuring against comprehensive or collision losses issued in the United States. Since insurance was invented in ancient Sumeria, when insurance policies were written on clay tablets, insurers and their insureds have struggled with establishing a fair method to properly and fairly compensate the person insured for the property lost or damaged as a result of a peril insured against. Insurance is a contract where one undertakes to indemnify another against loss, damage, or liability arising from a contingent or unknown event. The key question to be answered by the insurer is how much money is needed to indemnify the person insured. The concept of indemnity requires that the person indemnified receives sufficient funds to put him or her back in the financial place he or she was in moments before the loss. In normal disputes, diminution in value generally refers to a reduction in the worth of something caused by an action of a third party or entity. In the context of contract law, it refers to a breach of contract causing the decrease in value of property due to the failure to construct something exactly as specified in the contract. Diminution of value studies are often used in relation to real estate valuations in situations such as those that relate to condemnation or inverse condemnation litigation, such as studies of the impact of locating an airport near residences. Diminution in value studies are meaningful when based upon market data. Diminution of value is and should be understood to be by everyone the loss of financial worth of something because of damage. This concept often refers to vehicles, property, or other financial investments. With vehicles, the amount of diminished value depends on whether inherent diminished value or repair-related diminished value was the cause of the loss of value. Inherent diminished value means that there is some problem with the vehicle that was not caused directly by the accident. Repair-related diminished value refers to the loss of value following repairs after an accident. In fact, everyone knows that when you drive a brand new car off the lot, its value diminishes immediately. And therefore, that is part of the inherent diminished value. The claims person, when dealing with a claim for damage to a vehicle, must therefore, when a claim is sought for diminished value, seek the advice of local counsel to determine how the policy wording with regard to repair or replacement of the auto is interpreted in the state where the loss occurred, and how to deal with diminished value with the new exclusions and or with the law of the particular state. This video was adapted from my book, Zelma on Insurance Claims, Part 107, Second Edition, which is available as one of the 10-part series on Zelma on Insurance Claims, as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or interesting to your colleagues, please refer it to them. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.